Hello, everybody, and welcome back to Neutrality Studies. My name is Pascal Lotta. I'm an associate professor at Kyoto University, and today I'm joined once more by Dr. Keanu Sai, a senior lecturer in political science and Hawaiian studies at the University of Hawaii and the chairman of the Hawaiian Kingdom. Keanu, welcome to the show.
Thank you, Pascal, for inviting me again. Appreciate it.
Very glad to having you back. You are one of the few voices that is trying very hard through various legal and publicity projects to actually raise awareness for the situation of Hawaii, which you are saying has been now under occupation for 130 years. But the Hawaiian Kingdom, is your argument, actually never ceased to exist. Before we start with the updates of what has been going on, can you give us in a nutshell what you've been working on and how your project is working?
Well, you might say I'm a firm believer in lawfare, not warfare. And we've been engaging in federal court, United States District Court for the District of Hawaii. There's a federal lawsuit where there's a plaintiff claiming that a particular school that was established in the 19th century called Kamehameha Schools is subject to civil rights law under the United States. We intervened and we made the point that American law, whether civil rights law or not, has no application outside of U.S. territory because the Hawaiian Kingdom is an occupied state.
Right. The central claim of yours is that the Hawaiian Kingdom is currently should be under the law of occupation, right, and not under local law. You actually won an important case in the past, right? You didn't win, but you managed to have it at an international court. Can you maybe just recount this instance?
Sure. So, very quickly, just to precede what took place at the Permanent Court of Arbitration in The Hague or Den Haag, Netherlands. So, the Hawaiian Kingdom in the 19th century was an independent state. Okay, it existed as an independent state since 1843. Prior to that, since 1794, the Hawaiian Kingdom was a British protectorate. Now, in 1893, January 16th, U.S. Marines invaded Honolulu and illegally overthrew the government of the Hawaiian Kingdom the following day on January 17th. Now, under the law of occupation, or should I say, under international humanitarian law, the law of armed conflict, when you overthrow a government, sovereignty is not transferred to the occupier, but rather it remains in the state itself, despite the government being militarily overthrown. What happens is, according to 1907 Hague regulations, which was recognized customary international law in 1893, prior to 1907 and 1899. Article 42 in particular says territory is considered occupied when it is in the effective control of the occupant, right? On January 17, 1893, Queen Lili Okalani, the head of state of the Hawaiian Kingdom, conditionally surrendered to the United States and called upon an investigation to look into the U.S. invasion, which was unwarranted. The overthrow of the government then, through the surrender, effectively transferred control to the United States military, which triggered Article 42, which is occupation, effective control of territory. And then followed by Article 43, administration of the laws of the occupied state. The United States didn't do that. The United States, first of all, completed an investigation, found that the Queen was correct, entered into an executive agreement to restore the Queen, but they didn't. And 5 years later, in 1898, the United States Congress passes a law purporting to have annexed a foreign country. And since 1898, American laws have been imposed illegally in the Hawaiian Kingdom in violation of the law of occupation, right? Now, this federal lawsuit, excuse me, let me back up. The Permanent Court of Arbitration case stemmed from the unlawful imposition of American laws. So Lance Paul Larson, a Hawaiian subject, was alleging that the Hawaiian Kingdom, by its Council of Regency, restored the government back in 1997, is liable for allowing American laws to be imposed, which led to his incarceration. So that became a humanitarian matter. He suffered an unfair trial, criminal trial, and then unlawful confinement. Those are two war crimes under the Geneva Convention, Fourth Geneva Convention. Now, when we entered into that agreement with him to go to binding arbitration, right? We knew, and I was the agent for the Hawaiian Kingdom as well as the chairman of the Council of Regency, that that the Permanent Court of Arbitration was would be tasked with whether or not the Hawaiian Kingdom is a state, and I mean an existing state, not a nation with self-determination to choose to become a state, but rather a state in continuity since the 19th century, despite the government being overthrown in 1893. So I was in communication with their legal counsel at the Permanent Court, and she was asking for more additional information other than what she had already researched, because she had to determine whether or not the Hawaiian Kingdom, one, was continuing to existing as a state, and whether or not the Hawaiian Kingdom then would be a contracting state or a non-contracting state to have access to the Permanent Court. So all contracting states have access, but Article 47 of the 1907 Hague Convention for the Pacific Settlement of International Disputes provides access to non-contracting states. So I'll give you an example. Currently there are 127 contracting states, but you have 193 members of the United Nations. That means you have a large amount of states who are members of the United Nations that are non-contracting states, but yet they would have access. For the Hawaiian Kingdom, we're not a member of the United Nations, but rather a non-member of the United Nations, but a state nevertheless. And she confirmed they determined that Hawaiian Kingdom existed as a state.
Hey, very brief intermission because I was recently banned from YouTube, and although I'm back, this can happen anytime again. So please consider subscribing not only here, but to my mailing list on Substack. That's pascalotta.substack.com. The link's going to be in the description below, and now back to the video. Right, because of course, like the occupation of Hawaii started before the Permanent Court of Justice was founded, so naturally couldn't be a member. But so what was established in front of the Permanent Court of Justice is that the Court of Justice recognizes the statehood of the and the continuous statehood, right, of the Kingdom of Hawaii. But because that was confirmed at that hearing, then because they said that you had in fact standing in front of the court, right?
Yes. So that was confirmed, and that prompted Jaco Van den Hout, the Secretary General of the Permanent Court at that time. He was a Dutch national, and he spoke to me on the phone, and he stated to me that the Secretariat had concluded that they can find no evidence that the Hawaiian Kingdom ceases to exist as a state, and that the Hawaiian-Dutch treaty has not been terminated. Okay. And I believe that treaty was in 1863, a treaty of most favored nation status. So he then recommended to me, as the head of the government, to provide a formal invitation to the United States for them to join in the arbitration to answer as to the unlawful imposition of American law within Hawaiian territory that led to the claimant's unfair trial and incarceration, Mr. Larson. So that request prompted an exchange of notes that took place between the Hawaiian Kingdom government and the United States to come to an executive agreement. So the first note that was delivered by myself was after the meeting I had with counsel for Lance Larson in Washington, D.C., on a conference call with Mr. John Crook from the U.S. State Department. He's a legal advisor. And I remember in our conversation, he said, and the Permanent Court accepted this case because he knew what that meant, that they verified the Hawaiian Kingdom was a state, not the 50th state of the United States. So what we have there is I provided the formal invitation to the United States, and I reduced that conversation into writing, and that became the note or the offering instrument. right? So I sent that to Mr. Crook, and then I also sent a copy to the permanent court for record that the United States was provided an invitation. A few weeks later, I received a call from the Deputy Secretary General, Phyllis Hamilton. She's an American. And she stated that the American embassy, the ambassador, notified the court that they have an answer. They respectfully declined to join in the arbitration, but they asked permission from the Hawaiian government if they could have access to all records and pleadings. And I consented to that. And what we have there is an executive agreement. Now, this executive agreement is important because it is a treaty under international law by exchange of notes. So, coincident with the granting of permission to the United States to access all records was the United States recognition of the Hawaiian Kingdom and its Council of Regency as its government. And that was important right there. It wasn't just that the permanent court had verified the Hawaiian Kingdom still exists under customary international law, but now we have a treaty. And that treaty has come to be known as the Sai Clinton Treaty between myself, because I was in direct communication with the embassy, and the permanent court was brokering that agreement. And that embassy was representing President Clinton, who was a president at that time. So that was significant. That was significant. Now, what also is significant is that the permanent court, this is all before uh, the proceedings were instituted, because the tribunal was not established until June of 2000. This is March of 2000. Okay. Now, what is important is that not only did the United States recognize the Hawaiian Kingdom's continued existence and the Council of Regency as a government by treaty, but also by opinio juris, opinion of law or practice. So all 127 countries today, but back then I think it was less than that. I'm not sure how many. I think maybe it was 80 something contracting states. But no state, including the United States, protested or objected to the permanent court's designation and finding that the Hawaiian Kingdom, the tribunal was established pursuant to Article 47 for non-contracting states. So that became an acceptance of the practice. Now, the legal reasoning behind their not protesting or objecting, which is a part of opinio juris, you have the what, which is the action, and the why, meaning there's some legal requirement, is that under international law, there is a presumption of continuity of a state despite its government being overthrown. And that internal laws of any state has no extraterritorial effect. So there was nothing there that the United States could protest against, because international law, as the permanent court's legal counsel verified, it still exists. So we have opinio juris, and we have an executive agreement, and then we have a recognition by the permanent court as an intergovernmental organization, and actions taken by an intergovernmental organization, being that they are also made up of representatives of states, is considered an act of a state as well.
Your case is highly fascinating to me because it kind of runs counter to the current to the current development of international relations, in which we see again states just do whatever they want with their militaries and just claiming facts on the ground, right? You are doing the exact opposite. You're taking a legal route, saying no, wait, we have precedents and we have a case, and we can take this to the court internationally, but also locally in the United States, and we can use the legal system in order to establish at least the facts of the facts of the matter, and what is the case, and we work there in a long-term strategy to use the legal system to get back what should be the case, right? do you think, and we will get to the specifics of your new case in a moment, but the things that the United States currently does, let's say in regard to Greenland, but also especially in regard to Venezuela, where basically the United States is now trying to imply that its local laws, including gun ownership rights and so on, apply to the president of Venezuela. I mean, one of the charges against Nicolas Maduro is the illegal possession of firearms, right? Which is absolutely ridiculous when you think about what you just laid out. Um, in in the grand scheme of things, how do you think that this approach of the U.S., blatant of the U.S. government, blatant infringement on international law, but also like a really wild application of domestic law on foreign jurisdictions, um, how does that impact what you're doing and how you're approaching your case?
Well, the blatant violations of international law being committed by the United States administration, the current administration, only highlights the importance and significance of international law. Now, in our case, the violence occurred in 1893, January 16th, with U.S. troops invading. And our queen had to ensure that bloodshed would not take place because more so, the Hawaiian Kingdom was a neutral country by treaty. So it had to be very careful in its approach. It was never a belligerent, which would wage war, but we had a defense force, right? So what was in the minds of Hawaiian authorities in the 19th century was how do you utilize international law to preserve the Hawaiian Kingdom's existence as an independent state? And that's what prompted policy decisions regarding neutrality, government reform, and these things. So by the time we get to 1893, Hawaii is very progressive as far as a governing entity. And the Queen then was faced with gunboat diplomacy by the United States. And she had to walk that very carefully. She had some very good advisors. So she played the law to her advantage, but you can't stop the physical takeover. But at least the law will preserve. So when we look at it from today's standpoint, we merely in 1997 just picked up where they left off, but minus the troops, minus the threats. In fact, I have a military background. I served 10 years in the Army as a field artillery officer. So we were trained in the law of occupation, right? I knew about the law of occupation and sovereignty being intact, not as a political scientist, but as an Army officer, because we that's part of US Army Field Manual 27-10, right? So it it was an approach that we needed to do in a very comprehensive way without compromising the country any more than we could. So our actions in this case, what took place at the permanent court and what we will cover later in the show regarding the federal lawsuit is a part of the broader strategy of the Council of Regency. So we've been operating on a strategic plan that was developed in 1997 when the Council of Regency was we restored the government as a Council of Regency. So it's a three-phase plan. Phase one, verification the Hawaiian Kingdom continues to exist as a state. Okay, phase one. Permanent Court of Arbitration got us past phase one. Since 2000, we were in phase two. Exposure of the Hawaiian state. Legally, politically, through education. Just expose. This exposure will naturally force compliance into the law of occupation, where the state of Hawaii, as the governing body of the Hawaiian Kingdom, that governing infrastructure is from 1893. It's just the name change. They have to transform themselves into a military government, okay, in order to begin to administer the laws of the occupied state. So that's the goal. That's the objective. And phase three is when the occupation comes to an end by a treaty of peace, right? So here we are speaking about the permanent court, which was so critical in ensuring that a reputable body verified the Hawaiian Kingdom continues to exist as a state, not a political movement, not a matter of self-determination. In fact, as an occupied state, self-determination is applied differently than being colonized, right? So we're colonized, self-determination means you have of a right to choose. In the case of an existing state under occupation, your right of self-determination is deprived because you're not able to select your own leaders, your own control of your resources. So when the occupation ends, is when we can exercise self-determination, right? So that was an important aspect. So here we are in the exposure phase, dealing with a lot of not just misinformation and a false narrative that became accepted as true, but we had to adjust the terms. We had to apply the right terminology, the right law, the right theoretical framework, right? So one thing that we use to get people to do something they wouldn't normally do, I like to draw from realist theory, Hans Morgenthau.
Mhm.
At the national level, self-help, self-interest, self-preservation. Okay, well, at that level now, they're kind of echelons above reality, right? But we're getting closer. But what is happening is on the ground, you have that self-help, self-interest, and self-preservation, where let's say individuals in the state of Hawaii who are mindful and made aware of the factual circumstances that always occupy, which is a critical element in a war crime called mens rea, and the guilty mind. Once they can see that, then we can hold them accountable and say, if you're going to go this route, this is what's going to happen to you. And that starts to go from the bottom up. But the ultimate compliance has to take place from the top down, not the bottom up. So it's a very unique approach that we have engaged ourselves in. But this strategy and the engagement and making tactical decisions, meaning face to face, responding to a crisis, adjustment. It's all rule based, and we become a part of controlling the narrative because we have the standing of a real government of a state under international law.
And now, what did recently happen? You have now a federal case, right? In under US law. Can you maybe can you explain that one and how it plays into your grander strategy, which I must emphasize is a long term strategy. You're not trying to have this implemented tomorrow or 2027, but you're working on the long term, getting out of the occupation, even if it takes another 100 years. But maybe now about the case.
Well, I'm not waiting for 100 years.
Well,
So we actually have many things in place, triggers. They're already there. We just got to hit it. So this is not in isolation. There are many things that have taken place during phase two when we return from the Hague. It's just that what is on the radar that people can see would be, in this case, the federal lawsuit. So in this case, the issue in this lawsuit is students for fair admission basically are proponents of civil rights law in America, and that the affirmative action that gives preference to others who had some history of oppression, slavery. That's actually where it came from. Affirmative action gives them a head start, right? But by giving these students a head start, you're preventing other students from getting in that may be more qualified. And in the case of students for fair admissions, they filed a lawsuit against Harvard, and this was they represented 20, not 20, they represented Chinese students who were denied admission because of affirmative action. And they were saying that that was illegal because it's race based.
mm,
In 2023, it went to the Supreme Court of the United States, and the Supreme Court ruled that affirmative action is illegal. So this is the same plaintiff that has filed the lawsuit in Honolulu, in federal court in Honolulu, against the Kamehameha Schools that was established in 1887 in the Kingdom era. And according to the will and the intent of Bernice Pauahi Bishop, right, a high-ranking princess, the school preference will be given not just for tuition, but also admission to Aboriginal Hawaiians, meaning natives, both pure and part. So that's been in place since 1887.
Yeah, so now we're talking about a school that was founded even before the legal government of the Kingdom of Hawaii was overthrown, and that school continues to exist until now. And they had something like affirmative action already in 1887, and this group, the student group, now sued the school, right?
Because they're saying their argument is their clients are not native Hawaiians, and they were denied access to the schools. So for myself, I am a graduate of the Kamehameha Schools, so it's personal for me, as an alumnus. So uh, the problem here with that case, though, when they filed the federal lawsuit and applying American law, that is precisely the same situation with Lance Larson in his criminal trial. This is a civil trial. What is constant or consistent? American laws that are being illegally imposed in Hawaii. Now, what I also want to make mention of with regard to opinio juris, right? The action or practice taken by the permanent court wasn't just the recognition of the Hawaiian Kingdom as a state in their annual reports that every contracting state received, but also the case description on their website. That is their act. And it says that Larson is alleging that the Council of Regency is liable for the unlawful imposition of American laws within the territory of the Hawaiian Kingdom. The United States did not object to that, meaning they accepted that as true and factual, right? As part of opinio juris. That's a practice. So here we are, that the United States government, by treaty and by opinio juris, recognizes the Hawaiian Kingdom still existing, and the imposition of American law, which would include the Civil Rights Act, is unlawful, right? So that becomes the premise. So Kamehameha uh, is not going to raise any of these issues because they're a private entity and they're not experts in international law or well versed in it as we are, right? And students for fair admission will never raise these issues. So that prompted a meeting that I had with leadership of the Kamehameha Schools to see where they stood with regard to the Hawaiian Kingdom's interests as a government. And they said they took no position. Okay. Students for fair admissions objected to our proposed intervention. We're going to intervene in the case. So we're going to file a motion to intervene as a non-party. So we're not intervening as a defendant or as a plaintiff. We're going to intervene as a non-party because we're the Hawaiian government.
Mm.
We're going to ensure that history is going to be understood by the court accurately and applying the right law. So that was our opening to file that motion to intervene. Now, in the United States federal system, there is this doctrine called political question. So in a federal court, if there is an issue of sovereignty regarding a country and the United States executive branch has not recognized it, like in the case of Palestine, anybody claiming a Palestinian issue as a state under international law, the federal courts would deny jurisdiction based upon it being a political question until the executive branch acts upon it. And then once they act upon it, then the courts are bound by that, right? They cannot question it. So we anticipated students for fair admission would raise the political question doctrine when we filed our motion to intervene. Not Kamehameha, but students for fair admissions. So what we did was we kept out of our motion to intervene the executive agreement recognizing the Hawaiian Kingdom, and the opinio juris that binds the United States. We kept that because we wanted to respond to that their denial that we assumed they were going to make. What we didn't anticipate was that the judge was going to deny the motion to intervene, invoking the political question doctrine. And he filed that order denying our motion to intervene just 2 days after our motion was filed. So I don't know if the judge or the clerk of the judge even read it, but they assumed, I believe, that because we're talking about the Hawaiian Kingdom and they're not fully well versed on the particulars, they said it's the motion to intervene is denied because it's a political question. So what we did was we had 14 days to file a motion for reconsideration.
Mhm.
And the primary uh, uh, basis that we're going to rely on to file the motion for reconsideration is that the court committed a manifest error in its judgment regarding the Hawaiian Kingdom. And that is when we laid out in our motion for reconsideration the executive agreement that they recognized the Hawaiian Kingdom under President Clinton, and also the Council of Regency and also opinio juris.
Mhm.
Now, it appears that the judge hit the pause button because no decision has been made and we're going on 14 days, right? So it's an issue that is there, but it's not one to be litigated with regard to the Hawaiian Kingdom's existence. It's the impact that the Sai Clinton agreement would have as a treaty upon the court because the court is in a foreign territory. They're in the Hawaiian Kingdom, which means they're not properly constituted, which means any action taken by a court that's not properly constituted is depriving a person of a fair and regular trial. So now comes in the Fort Geneva Convention, right? So that's the opening that brings these issues to the forefront. And that has been a very foundational basis where it's raising eyebrows here in Hawaii because it's very legally based.
Yep. And you're forcing that consideration upon the court now, right? I mean, you're using the court system in order to go after these detailed legal questions, but with each one, you're creating new building blocks in order to take the next step to prove that, well, the Hawaiian Kingdom is still very much here and is very much a legal entity and never ceased to exist, even if you ignored it. And so now you're at the point where you're waiting for that judge's decision, because once that is given, I suppose that then the students for fair admission would have a next chance to basically apply for the denial of your request to intervene, right?
Okay, so again, it's when you're in a fight, you don't show all your combinations. Right. So when we filed that motion for our motion to intervene, our strategy was in order to show the court what the laws are, what the facts are, and you have to administer Hawaiian Kingdom law, was to get the court to begin to administer Hawaiian Kingdom law in this lawsuit. That was the basis of our intervention. So we're not denying students for admission a bite at the apple with Kamehameha. The difference, though, is affirmative action under American law is illegal, but the Hawaiian Kingdom, under its laws, has a form of affirmative action where the policy of Kamehameha is in line with Hawaiian Kingdom law. And we have a court case in 1863, Rex versus Booth, that clearly articulates that with regard to the native population. So, it's like make sure the playing field is fair.
Right.
So don't denying students from fair admission, you can't do this. No, you can make any allegation you want, but you have to apply the right law. Now, what has happened though, as a consequence of the judge's decision to deny our motion and then now our motion for reconsideration, we have now taken it to another level. The executive agreement, the treaty basically says United States recognizes the Hawaiian Kingdom, and this federal court does not exist. Does not exist. Not that it needs to administer Hawaiian Kingdom law. So now it puts an issue to be well, it places the issue now on legalities with regard to not just students for fair admission, but also Kamehameha schools. So what is now happening in my meetings with Kamehameha leadership is that Kamehameha, as an estate, a probated estate, which is a legal person under Hawaiian Kingdom law, not a physical person, but a legal person, a juridical person, right? Um, that is under Hawaiian Kingdom law, but the current administration of that estate is under American law. That's a problem. We have a collision because you cannot be under American law in the Hawaiian Kingdom when the United States already recognized current existence of the Hawaiian Kingdom and the Council of Regency. So we were trying to get the Kamehameha leadership, the trustees, and the CEO to take affirmative steps to show that you have allegiance to the Hawaiian Kingdom, the country, because allegiance has not changed despite a prolonged occupation because sovereignty is still intact. Now, during occupation, you can argue the occupier may demand obedience, but not allegiance, because if they demand allegiance, that's a war crime, right? So we need to understand that aspect of the impact of this law on private people today. And that's where it gets into self-help, self-interest, and self-preservation. So if I'm going to look at the issue here with the current administration, which is really just a microcosm of everything in Hawaii, right? It's not just the leadership of Kamehameha. It's just a direct nexus to an estate, a legal person under Hawaiian Kingdom law. And the only way that that estate can speak is it needs to have representatives by virtue of the will of that estate. The will is not being properly applied because it's all under American law. So here we have a situation where you have assets of this estate that is paying the salaries of the leadership or the estate today under American law. There's a disconnect. So now I can say, as a head of the Royal Commission of Inquiry, which we investigate war crimes, possibly Kamehameha leadership could be committing the war crime of usurpation of sovereignty, which is the imposition of the occupier's law, as an accessory after the fact. Because after the fact, they were made aware. What triggered after the fact accessory is because they were made aware through the pleadings in this case that Hawaii is occupied and that Hawaiian Kingdom law applies. So the continual uh, uh, receiving of monies from this estate becomes the accessory after the fact usurpation of sovereignty in how they became trustees under American law, which is usurpation of sovereignty. Another aspect of the impact of the of war crimes would be pillage, because that's a private estate in the 19th century, and these are private people. Okay, now we're talking about appropriating assets without the consent of that other private person. So then we also get into, under Hawaiian Kingdom law, theft, because you are receiving funds from an entity without the consent. So the implication here now, as it always has, applies to everybody within Hawaii to a certain degree. So what has to happen here is for the trustees and the chief executive officer, they need to come under Hawaiian Kingdom law, and that under our laws would be by virtue of Section 430 of the Hawaiian Civil Code, sign an oath of allegiance. That is evidence that you're under Hawaiian Kingdom law, right? Now, what's interesting is 1893, the insurgents, when they took over the Hawaiian Kingdom government and they were being protected by US Marines, they forced everyone to sign oaths of allegiance to them who were being protected by the US Marines. But they maintained the governmental infrastructure. So what we have that we put together in our operational plan, well before this federal lawsuit even took place, is to bring the status quo back to what it was in 1893 before the US invasion. And there's essential and implied tasks. So basically what we're doing is it's a form of reverse engineering,
Mhm.
reversing everything that occurred in 1893. We're not coming up with new ways of looking at it. We're just reversing it legally. So the oath of allegiance that would need to be signed by individuals in certain positions, in this case, it revealed itself because of the federal lawsuit. It's just the form of reverse engineering that and bringing it back to the, the Hawaiian Kingdom, its umbrella, the sovereignty. And that's when it gets very gets people here in Hawaii very uneasy.
Are you getting pushback now, not just on the legal front, but by people? I mean, you're really scratching now on a surface where you might trigger powerful people with money and people with offices to start noticing you and to maybe want to shut that whole thing down. Is that already happening?
No, no, no.
So
It's so it's so legally and historically based that really what our protection is the exposure that what we're doing is just following the law.
great.
So take a look at the benefits of this. Okay, so let's take a look at from a realist standpoint. If I'm living in Hawaii and the cost of living is killing me, the majority of Native Hawaiians live in America now because they can't afford living in their own country, their own home. Not that they know it's their country, right? Under Hawaiian Kingdom law, every Native Hawaiian gets free healthcare at Queen's Hospital. That was the law in 1893 since 1859. Okay. Also, property. Every Native Hawaiian, because of vested rights in the land, can get up to 50 acres at 50 cents an acre, which according to the inflation calculator is $17 an acre, right? So we're looking at these issues that hit home for people, meaning self-interest, self-preservation. So that kind of gets them thinking. And then if you take a look at it from a tax standpoint, taxes in Hawaii, they're being triple taxed, federal, state, and county. Under Hawaii Kingdom law, it's just one tax, right? So when you look at it from a business standpoint, you don't pay IRS taxes in a foreign country called the Hawaiian Kingdom. You pay Hawaiian Kingdom taxes, which is currently being collected by the state of Hawaii. We just got to get them to transition. So the driving force here, the law is the basis, but it's really economic factors. And it's where individuals start to look at themselves going, wait a minute, wait, what is going on here? Not that they need to fully comprehend the scope of what you and I are talking about, but what they want to see is something real. And in the case of the federal lawsuit, it's it's bringing that to fruition. It's like this is real. This is not speculative. But for me, as a former Army officer, it's task oriented and a methodical approach. So the long term aspect of this is what we're dealing with is our enemy here, because we're in a state of war. We're occupied. That's a state of war. We're not in a state of peace yet until we get a treaty of peace. But the enemy for us is ignorance. Nobody knows. So
Right.
how we deal with ignorance is through education and critical research, publications, My recent publication by Oxford University Press on the Hawaiian Kingdom's continued existence as an unconquered state has taken our story at the highest level of academia worldwide. My forthcoming chapter on Hawaiian neutrality in your folks is volume 2 on neutrality studies, addresses the Hawaiian Kingdom's approach on how to preserve itself in the 19th century as a neutral state. So, so the conversations have to be normalized, and that's why I'm not into rhetoric, but constructive dialogue, um, and also addressing a lot of ignorance here in Hawaii. So I'm also a senior lecturer, and I teach political science and Hawaiian studies. And every class, for over 20 years, they all see it. They're just it's like the light bulb popped on. Uh, but they go, but then they also realize that the Council of Regency has a plan. It's understandable. I can understand it. I'm now looking at my children and my possible grandchildren. So there's so many aspects here beyond just the law, but it is legally based.
Now, what I find very important about your example is just the that you're proving that if you don't agree with the state of affairs, how things are running, there are options of what can be done. We are not condemned to just like fold our hands and say like, oh no, everything's so bad, boo hoo. There are things that can be done, and your way is a very, very interesting one, using a combination of international law and domestic law and legal reasoning and not just legal theories, but the application of the law in order to do something. So I encourage everybody to study your case of the Hawaiian Kingdom and the Council of Regency in order to see how it can be used as an inspiration for other cases where we don't agree with what's going on, but we wonder what can be done. Keanu, people who want to follow your case, who want to see what's going on in the federal lawsuit and so on, where should they go?
So, uh, real time stories, up to date stories are posted on the blog. So it's the Hawaiian Kingdom blog. Um, I don't know, well, it's hawaiiankingdom.org/blog. And it'll prompt you to subscribe. And that way, anything that is posted, you get notified. So you don't have to keep checking what's the latest. But that I would say is the one the one place that people should go if they want to see it. And there's also a search engine, and there's many blog posts that go back years. And it's a good teaching resource as well.
I will put the link to the blog into the description of this video below. Dr. Keanu Sai, thank you very much for your time today.
Thank you, Pascal.